5 seconds to go. Start. Having given anxious consideration to the rival submissions and having examined the record, we are clearly of the view that the impugned order dated 3rd December 2020 cannot be approved from any standpoint. A perusal of the order impugned makes it clear that, in essence, the principal part of submissions before the High Court on behalf of the present respondent number 2 while seeking bail had been that the co-accused persons had been granted bail and he was entitled to the same relief on the ground of parity because his case was standing on identical footing. The other submissions had been that the respondent number 2 was in custody since 2nd September 2019, that he had no criminal history, and that trial was likely to take time. The High Court did not consider any other aspect of the matter at all and proceeded to grant bail to the respondent number 2 only for the reason that the so-called identically placed co-accused persons had already been granted bail. The fact that the order granting bail to the co-accused Fahim met with its strong disapproval by this court remains rather indisputable. In the judgment and order dated 15th March 2021, this court took note of the fact that the High Court had granted bail to the co-accused while ignoring the relevant considerations and with a mere reference to the mandate of Article 21 of the Constitution of India. The relevant observations and comments by this court in the judgment and order dated 15th March 2021 could be usefully extracted as under. The circumstances would indicate that a brutal murder has been committed of the son of the appellant. The post-mortem report would indicate as many as 8 ante-mortem injuries. The offence is alleged to have taken place in broad daylight. The first information report being case crime number 438 of 2019 was registered at about 2108 hours within a period of 4 hours of the incident, which is alleged to have taken place at 1715 hours on the same day. After the investigation was completed, the charge sheet has been submitted before the competent court under section 173 of the Code of Criminal Procedure 1973. In several judgments of this court, the need for the High Court to adduce reasons while granting bail has been underscored. At this stage, we may advert to the recent decision in Mahipal versus Rajesh Kumar, which was relied on by Ms. Bansuri Savraj, Learned Counsel for the state of UP. Speaking for a two-judge bench, one of us, Justice D.Y. Chandrachud, judge, observed, merely recording, having perused of the record and on the facts and circumstances of the case, does not subserve the purpose of a reasoned judicial order. It is a fundamental premise of open justice to which our judicial system is committed that factors which have weighed in the mind of the judge in the rejection or the grant of bail are recorded in the order past. Stop.